Everyone, it is not often that someone that I just met in person a few days ago, I get to interview. And this person today, whose name is Ashish Joshi, we have interviewed before a couple of times. He has just come out with a new book. I think I called it, Litigating Parental Violence, but I think it's Litigating Family Violence. Here he can get on smoothly. The last time we tried, good, good. So I was just saying it was so awesome to meet you in person last week. Uh-oh, I'm hearing a weird echo. Let me see if I can fix this.
Let me see. I got a new phone, so my stand apparently is not working for this one.
All right, let's see if this works. Oh, now I don't hear an echo. Okay, good. But anyway, so Ashish, we got to meet in person last week, just a few days ago at the AFCC conference, which was so cool because we had done a couple of these interviews before. But I always tell people that you are the dream team of attorneys. You are a domestic violence attorney that specializes in parental alienation, and you have helped many of our clients who we send to you as if you were the specialist of specialists, like a doctor, the best. So thank you so much for the work that you're doing, and thanks for taking the time to come back on with me today.
Thank you, Lisa. It's a pleasure to be here with you.
Yeah. So before we even start, the last book that you did, which I loved and which our new book has loads of information on, was Litigating Parental Alienation. But this new one is called Litigating Family Violence.
That's right.
What is family violence?
So when we talk about family violence, it's an umbrella term that includes a lot of things. It includes domestic violence. It includes intimate partner violence. It would include coercive controlling behaviors. It would include emotional abuse, financial abuse, sexual abuse, using immigration tools as controlling tactic. It would also include abduction of children, sometimes outside the country, international abduction as well. And it would include child psychological maltreatment and weaponization of children, which is what alienation is.
All right, tell us a little bit about your background. I just said like one sentence, and what made you write this book since writing the last book? Why was this so important?
It was important to talk about family violence from a broader perspective. Parental alienation is just a teeny weeny part of family violence. It was a very special topic that I wrote my earlier book on. And often there's an interplay between alienation and family violence. So, for example, you would see cases where one parent is engaged in alienating behaviors or gatekeeping behaviors, but there is also evidence of the other parent behaving very inappropriately. Maybe the case has a history of domestic violence. Maybe the case has history of some trauma that has never been resolved or diagnosed. So there is interplay in all these human behaviors, which needs to be taken a look at from a holistic standpoint. The other reason I wrote this book was to address some of the misconceptions and some of the fallacies regarding parental alienation that we filed in family courts. So, for example, men are victims as well. We are seeing more and more research come down from social sciences that talk about men being victims of coercive control behaviors, men being victims of intimate partner violence in heterosexual relationships and also in same-sex relationships. We also keep on seeing the same stereotypes and misunderstandings of family violence, where a victim who is trying to leave the abusive relationship is often asked or questioned, well, if it was so bad, why didn't you leave earlier?
Mm-hmm.
People don't understand that leaving an abusive relationship is a process. It's never an event. So these situations kept on coming up in my line of work. And while there are academic books that dive into detail, there were peer-reviewed studies, there are research studies, I didn't find one book that addresses the whole topic, the whole umbrella term, from a broad standpoint. someone who can read the book without having a background PhD in psychology or social sciences, whether you happen to be a family court lawyer dealing with these cases, or you happen to be a litigant representing yourself in family courts. I
So
also
go ahead.
wrote this book because as I teach these issues and these topics at legal and judicial conferences, I often got questions from judges who were in a rural circuit, for example, Michigan rural area or Indiana, Virginia, you name it, and who complained that they don't have the resources that they need. That forget about the experts who can come and testify. In most situations, the litigants who were in front of them were pro se representing themselves, and they didn't even have attorneys. So I also try to help out judicial officers who are in trenches and explain how they can make findings of fact in these cases.
Yeah, so I noticed that with the title of this book, it says for practitioners. So I thought, oh, that's mainly for professionals, but you just mentioned it's for litigants also who specifically are pro se, because we know how much money and time and energy it costs to deal with cases like these really difficult cases. And you know, Chris and I only work with high conflict, extreme situations. And so many of our clients, including me from years ago, ran out of money and have to represent ourselves. Are there other misconceptions that you've seen when people try to put together a case where there is, let's say, alienation going on, and they just show up, I imagine, with lots of research that they want people to look at?
Sure. So let's go back a little and talk about the term that you mentioned. You mentioned high conflict cases, you know, and in cases involving alienation or severe parental alienation, it would be a mistake to call that case a high conflict.
Mhm.
It certainly involves conflict, no doubt about it. But a high conflict case typically involves two parents or two parties who are simply unable to agree on co parenting and who have to argue and litigate every little issue. They can agree on a pediatrician, they can agree on a which camp to send the kid to, they can agree on school, they can agree on after school extracurricular activities, and everything needs to be litigated and taken to the court.
Mhm.
That's a high conflict case. That's what we mean. In a case involving alienation or child psychological maltreatment or emotional or coercive control behaviors, we have a situation where one party, typically but not always, is engaging in this abusive behaviors, and the other party and or the children are reacting to those behaviors. Now sometimes the reaction is poor, where the victims lashes out on the social media, starts sending aggressive text messages, starts calling the attorneys and judges and guardian ad litem and all of those things, because there's a lot of anxiety surrounding this. But that situation is not a high conflict situation. It's a situation involving family violence where there's a
Well,
abusive, where
I've been
there's,
labeling it wrong then.
yeah, because the high conflict somehow makes an assumption that both parties are to be blamed equally.
Hmm.
But in family violence, you have an abusive behavior at one hand, and then you have reaction to that abusive behavior. Now, maybe the reaction could be better with proper coaching and proper therapy and proper intervention. But the person who is reacting to abusive behavior should not share the blame for causation.
Yeah. One of the things that I don't know if you went to this workshop at the conference was about asymmetric control, where there's such a power imbalance in the relationship that it contributes to the dynamics that you mentioned. And often the parent who doesn't have as much resources or power and control does get very reactive because they feel completely misunderstood and that the stakes are against them.
It does happen, and it's a very stressful place to be in. It's almost a surreal experience that you don't know what's going on.
Mhm.
And even though you are at the receiving end of abusive behavior or controlling behavior, somehow professionals and your lawyer or the judge or everyone is looking at you as somehow contributing to this dysfunction in the family. And
Mhm.
that this significant and tremendous amount of anxiety.
Yeah, for sure. So, what are some other misconceptions that people have about these kinds of cases? So, I was labeling them wrong. What about someone going into court, let's say pro se, their children have been turned against them to a certain extent, and they are terrified, and they're using the word parental alienation. Another thing I learned at the conference was that, I mean, we already know that it's a controversial label, but that we should be using the term PCCP,
Parent-child
parental. Yeah,
problems.
yeah, but nobody knows that I couldn't even remember it right now. Should
Well,
people be saying that instead?
I think we have to be careful, and we can't use these terms interchangeably. So, for example, when we use the term PCCP, parent child contact problem, all we are saying and all we are telling the court is that there appears to be some problem between the parent and the child. Either
Hmm.
the child is refusing to see the parent or refusing to have a proper relationship engagement with the parent, but there is some sort of thing going on where every visitation is a tug of war.
Hmm.
The other term for that is resist refuse dynamics, where
Hmm.
children demonstrate these behaviors. But that doesn't really tell you why. That doesn't tell you why is the child resisting seeing a parent. Is it because the parent has deficient parenting? Is it because the parent is abusive? Is it because the child never had a relationship with the parent to begin with? Or is it because the other parent, who is a favorite parent, influencing the child to reject the former parent? Or combination of all of them? It could be
Hmm.
a hybrid situation as well. So the problem with the term parental alienation is at times it's simply overused in courts.
Hmm. Like narcissism.
Narcissism, gaslighting, histrionic, bipolar, people throw
Yeah.
out these labels, especially when they are frustrated and they are angry about it. There's a difference between parental alienation, which is a stage or a phenomenon where the children or a child has been alienated against a parent, versus parental alienating behaviors, what are known as PABs. Now, evidence of parental alienating behavior doesn't necessarily lead to parental alienation in every case. Maybe the child is resilient. Maybe the underlying bond between the target parent and the child is very strong, and they are able to overcome the alienating behaviors. But that doesn't mean we leave those behaviors unaddressed. We still have to bring it to the court's attention. We still have to try to get the family, the parents, and the child some early intervention, some psychoeducational tools for behavior modification, and all of that.
Okay.
So it depends upon what stage the case is in, what evidence do we have, what are the facts, because everything revolves around the facts. The same kind of behaviors, you have to understand the context. If a parent A, mom or dad, is trying to prevent the child from seeing the other parent, or is trying to what other people call interfere, you know, it is certainly a kind of gatekeeping behavior. But why is that happening? Is it because the parent is genuinely concerned about the other parent's parenting skills? Are there issues involved regarding alcohol or substance abuse? Is the other parent being neglectful? Is there protective gatekeeping, restrictive gatekeeping? What's going on? So you have to take a deep dive and determine what the facts are, and have the court or some kind of a court appointed professional make some findings of facts.
All right. So let's say I am separating. How do I know when is the appropriate time to even bring this matter to the court versus dealing directly with my ex or my child when there's been resist refuse dynamics?
If you are seeing resist refuse dynamics, if the child is rejecting a parent, if a child is refusing to come to parenting time, and the other parent happens to be just content with that situation and continues to blame the former parent, we know there's a red flag right there. The
Hmm.
sooner you get to the court and the sooner you get some kind of intervention, the better off you are. Now, it doesn't have to be that you rush to the court and start pointing fingers and pass the blame on. Maybe the better thing to do in a certain situation is to go to court and ask the court to give you some tools regarding early intervention. Maybe to ask the court to order family systems based counseling or some kind of brief assessment as to what's going on. Why is the child rejecting or saying no to visit a parent? What's the other parent doing about that? Is the other parent simply throwing up his or her hands and say that's for the child to decide? Or is the other parent stepping up and being a co-parent and say, well, let's resolve the situation. How can I help? What can I do to make it better?
Yeah. So that's not the situation that any of our clients are dealing with someone who's saying, let me make it better. It's the opposite. But so you're talking about psychoeducational tools. That's earlier. Now let's talk about later, where it's severe alienation or whatever the reason was. And a parent is saying, I need to go to court, but my kid has no contact with me. And it's been 2 years and they're 14 years old. So they're old for the system, or 16. Is there anything that people can do when it's gotten that extreme?
Well, so first of all, I personally believe that no child is ever too old as long as the child happens to be under the court's jurisdiction and not emancipated. The court must do whatever is required to save the relationship and ensure that the child is able to see the parent and the parent is able to see the child as long as the child is safe. Okay. And I've written about this, and there are judicial decisions that talk about it as well. Now, some judges do feel that older teenagers who are 16, 17, going on 18, you can't quote unquote force them.
Mm-hmm.
But it also depends upon how you view the term or the word force. Because a parent who often claims helplessness in having the child go and see the other parent is able to make the child go to school, go to medical appointments, do all sorts of things. And it's only when the question arises of seeing the other parent when they claim, oh, I can't really make the child do that. So the courts have to look beyond that. In severe cases of alienation, where there are findings made of alienating behaviors and how the child has been affected, sometimes the courts change custody, sometimes they flip custody, sometimes they place the child with third parties, maybe foster parents, or at times private residential boarding schools. There are certain programs which are meant for severe cases of alienation. And I know there's a lot of controversy surrounding some programs or what some people derogatory call them as camps.
Mm-hmm.
But you have to look and research each program to see whether it's a proper fit for your case or not. But at the end of the day, what the court does is to give the child and the parent who's being rejected plenty of parenting time so that they can experience each other and the child is able to overcome some of the distorted perceptions or skewed perceptions he or she has about the parent. And then the other parent who has been a favorite parent but has been somehow sabotaging the relationship or trying to fan the flames of the child's resistance inadvertently or intentionally should also be made part of the family systems approach, where a good clinician works in the whole family, looks at the family dynamics. You can't treat alienation in a vacuum. Usually, cases that are successful take a holistic approach to it.
Yeah. So I'm going to throw a situation at you that it's been haunting me. And this isn't the only time that we've seen this happen. So let's say a kid has been turned against another parent by the favored parent. There's an order for reunification therapy. The targeted parent has been waiting months and months, but the way that the order was structured just said therapy is ordered, but there's no deadline, there's no expert appointed. And the favored parent, preferred parent, is delaying. So months are passing and nothing is happening. What relief, if any, is possible to get some kind of clarification to get it moving along?
Well, First of all, that's an instance, if that's how it happened, it's an instance of poor court order, which was
Hmm.
not appropriately written or entered. Because in cases involving alienation, it's a common tactic for the favored parent to run the clock out,
Hmm.
simply stonewall, delay, and cause additional delays to wait the child to get to 18. So in that situation, I would, if I were the attorney representing the targeted parent, and there are findings of alienation, it's an alienation case, I would go back to the court and ask the court to clarify the order and to make sure it's concise but comprehensive at the same time. It also is detailed. We need to know who's the therapist or who's the counselor going to do reunification. We want to make sure that the reunification counselor, once appointed, gets findings of facts that this case is about alienation. It's not about estrangement. It's not about some kind of other kind of abuse, but it's this is what the court has found. These are the issues that we need you to work on.
Hmm.
I would also make it clear as to what's obligation for the favored parent. If the favored parent is tasked with bringing the child to therapy sessions, we want to make it crystal clear. And what's going to happen if the favored parent can make the child go? Are there going to be consequences? Are there going to be makeup sessions? Are there going to be financial sanctions or attorney fees awarded for missing those things? So you
Hmm.
have to have teeth and some details to these orders as well. But another thing to remember, Lisa, what I have found is even where the judges enter such kind of orders and they want to help the family, it's never a set and forget situation.
Hmm.
It's not a one time deal. I mean, cases that actually get better and where we are able to make a difference is where judges and the judicial officers are willing and maintain a judicial oversight over a period of time. So they would enter an order for reunification or family systems based counseling, and they would have a review hearing after, let's say, 3 or 4 months. It could be done by Zoom or by remote means. It could be very efficient, doesn't have to be a whole big exercise. But there's some sort of judicial oversight on the whole process. So if the appointments are being missed, if people are not participating in good faith, or if the rejected parent is reacting poorly and keeps on arguing with the child and not following the lead of the reunification counselor or the parenting coach, the judge has an opportunity to catch those things early on and make the attorneys go and work with the clients, or if there's a guardian ad litem involved, have the GAL work with the kids. But there's some sort of judicial oversight which allows them to modify or tweak the treatment modality as they go along. That's
Yeah.
where these cases are the cases where they can make a difference.
Yeah, so what you call judicial oversight, sometimes we've heard the term case management, but it's basically having eyes on the case, not just you get the order, bye, and the only time we'll see you again is if someone files because someone has not followed it. So I love that idea. Another thing that we see constantly, and I don't know if there's a way to do anything about it, is with these older kids. And I agree with you. I think until a child is 18, why not still try to get the court to do something about it, because we know the impact it has on not just now, but their relationships for the rest of their lives, their ability to build resilience or to learn conflict resolution skills. But where a judge will say, okay, well, this kid is 15 years old, so I'm going to let the child decide how often they want to go to therapy. And then they're getting so much pressure from the other parent. Is there anything that can be done where a judge has already said, well, let's leave it up to the kid because, again, I'm throwing up my hands and we can't make them do anything?
Well, I would be surprised if a judge just say, let's just let the kid decide. I mean, most judicial officers understand that there's a difference between respecting the voice of a child and giving the child the choice.
Hmm.
Children do have voice and do have to be able to put their voice out. But at the end of the day, they don't get a choice. They don't get a choice whether they will be seeing a parent or following court orders or visitation and all of that. And that's where a good guardian ad litem or minors counsel can make a difference. who can put that voice before the court and explain to the court what the child wants and why. But then you have to exercise professional judgment and explain to the court whether just giving what the child wants is in the child's best interest or not. I mean, we have peer reviewed studies and research that show that in cases where the courts intervened and required the child to have relationship with the rejected parent, required the child to go through family systems counseling and reunification, the children, when they grew into adults, were thankful for that. They
Yeah.
were happy that the court intervened and were able to save their relationship with the other parent. Because
We've seen the
they were
flip side.
interviewed after, yeah, they were interviewed after a time they become adults as to what was their experience. And most of them said that it did cause anxiety, it did cause stress at that point in time, but overall they were happy that the court simply did not give up, and the court made them and the parents participate to this process to repair the relationship.
Yeah, I was going to say we've seen the flip side, where kids who have grown into adults were given the choice of whether they wanted contact with the parent, and tremendous anxiety and guilt for deciding not to see the parent, and then going back as adults, young adults, and then saying, "Oh my gosh, I feel so bad." Personal friends of mine have had that experience. And we've got a situation now where a court did order therapy, but said the child can decide how often they want to go to therapy. And so I know. So it's been a disaster because the therapy went well when it finally happened. And the child told the therapist that they were willing to meet more frequently. But then as soon as the preferred parent picked them up, the preferred parent said, "You don't want to see the other parent that often. You don't have to go." So the pressure was right there in front of the targeted parent and the therapist. And I thought, oh,
Yeah.
what can be
I mean,
done?
that is really ridiculous to put the burden on the child to decide how frequently therapy should be conducted. I mean, that's just beyond absurd.
Yeah.
And even in some situations, even the judges or the courts can control that. I mean, the decision as to how frequently the session should be held and how long, I mean, that's a decision that the clinician has to make
Hmm.
after observing the parent child interaction, after talking to the child, after talking to the parent. You can't force those decisions upon a clinician. Now, in certain situations where the therapy is not going the way it should, or if the sessions are being missed, or if the clinician keeps on just talking to the child without talking to the other parent or bringing them together and it's taking a lot more time than it should have, you can always go back to court to ask these questions. Because in some situations, if you have a therapist who is not skilled or experienced in the area of child alignment, alienation, they often start just buying the narrative put forward by the favorite parent in the child, ignoring the court findings.
Hmm.
And then the answer is, well, the child is not ready. The
Right.
child is not ready, despite the court having made findings of the influence on the child by the favorite parent. And in that situation, as long as the child keeps on going back to the favorite parent after 45 minutes or 1 hour in therapy, the child is never going to be ready.
Right.
So it's a judgment call that the clinician has to make in these situations. But
Yeah.
there was an article that I did a few years ago, and it's on my website. You can find it called "No Leave No Child Behind," and it's a roundtable interview that I did with Dr. Richard Warshak,
Hmm.
and one of the senior judges from Michigan Court of Appeals and a trial judge from New York, who is a former domestic violence prosecutor. And we talked about the interplay between DV, PA, resist refuse dynamics, and all of it. And the judges made a point that in no area of law we over empower the children like we do sometimes in family law.
Mm.
I mean, we don't allow 16-year-olds to go and join the army. We don't allow 15-year-olds to drop out of the school and start smoking marijuana. We don't allow kids to do a lot of things. That's what parenting is about.
Hmm.
But sometime when we come to these cases involving alienation, abuse allegations, children at times are way over empowered.
Hmm.
They should not have the burden to make these decisions. The judges spoke out about it.
Yeah, that came up when we were at this conference in London on this topic, and it talked about how the voice of the child is something, but you always have to have adults looking at the broader context and what the benefits would be to certain schedules and decisions. Because sometimes there is no benefit. It's just like, well, this is what I want. Well, how is it going to help?
Yeah. And I would go a step further and say that voice of the child is all well and good, but you have to determine whether that voice is genuine
Mm,
or
yeah.
whether that voice is a product of influence or contamination through alienation or otherwise.
Yeah, absolutely. So, back to these cases where somebody is dealing with a situation with family violence, often the question comes up about expert witnesses. So, if someone's saying, I have to help reunify with my child, but the court doesn't really understand what's happening, what type of witness should they get as an expert? Well, I've heard that a trauma-informed therapist who specializes in adolescence is important. Do you see certain types of witnesses that are more effective?
It's a tough question to answer because every case is different.
Hmm.
At the end of the day, as a litigator, as a trial attorney, as someone who goes to courts, you have to pitch your message to the audience.
Hmm.
So a lot depends upon who your judge is. Is your judge an experienced family court judge who has been on the bench for a long time, who understands these complexities involved in these cases? Is your judge a new judge who has been recently appointed to the bench and who is not that well versed in the family law, who might need more education to understand what alienation is all about?
Hmm.
Are you, or do you happen to be in Texas where you are gonna talk to jury? Because in Texas, it's a jury that decides child custody or parenting time issues on a preliminary setting, and then the court decides later on. So a lot depends upon those issues. It's also not necessary that you need an expert in every situation.
Hmm.
I mean, experienced judges make fact findings all the time. There are good decisions, from Canada, for example, Ontario courts, where they have said that we don't need an expert to tell us about whether alienation exists in a particular case.
Hmm.
Trial judge could make findings of fact depending based on the behaviors of a parent. I mean, some cases there are flagrant violations of just common sense. I mean, there are cases where I'm just making this up, it could be mom or dad, but let's say dad is the alienating parent. And there are instances of the father sending text messages to the child, copying the mother, denigrating the mother, bad mouthing the mother, telling the kid that she doesn't deserve respect. Just because she gave birth to the kid doesn't make her a mom, calling her horrible names. The child is looking at all these text messages, happens frequently. Now, that kind of behavior, you don't need an expert to tell the judge it's inappropriate,
Hmm.
it's alienating. The court will make findings of such behaviors. So often we lose significant amount of time because we have to go and retain an expert. We
Hmm.
have to get the expert to get up to the speed to the case. Then we need to find court dates where the expert can testify. Some dates are given where the expert's not available or the judge is not available. And you lose months
Mm.
sometimes. Precious time is lost. So compared to that, if you have evidence of some really concerning behaviors, you might be better off going to the court without an expert and putting those before the court and trying to make a case as to deficient parenting, alienating behaviors, grossly inappropriate parenting, all of it.
Yeah, it makes sense. So now I'm thinking of a situation with one of our clients, which was extreme, and custody was completely flipped. And our client got it finally after horrific behaviors from the other side. The problem is that the child who's a tween is still in very close contact with the alienating parent. So the child is living with our client, but dealing with and on the phone constantly with the alienating parent. Our client's lawyer has told our client, you got to get the phone away from the kid because they're still being fed these terrible messages, which also have been communicated in text. And now our client's lawyer is going to have a field day. But what do you think about when a targeted parent has been awarded more time, but the alienated child is still in such close contact? Should they get rid of the phone, or is it too extreme for that? I mean, I know this is specific and you're probably not going to want to answer it, but have you seen situations like this?
I think situations like that. I mean, I can't answer what to do in that particular case
Right.
because, I mean, you'd have to listen to what the attorney is saying. But generally speaking, there are always two sides to resolving the alienation situation. One is giving the rejected parent and the child sufficient time to repair the relationship and bond and reunify.
Mm-hmm.
But there also have to be put safeguards around that relationship and time, where the favored parent is not allowed to sabotage, to interfere, to undermine.
Mm-hmm.
So while the reunification is going on, one might consider, for example, restraining orders in place or
Hmm.
no contact orders in place where the favored parent is not allowed to contact the child. The burden should not be on the child to reject the favored parent or to say no to the parent.
Mm-hmm.
That burden should never be put on the child. The child should not be put in that situation where he or she has to prove loyalty or to be appear disloyal to that tribe. Because this is the tribal mindset that we're
Yeah.
trying to overcome. The burden should be on the adult, on the parent.
Mm-hmm.
While the child is going through reunification, and unless some progress is made, you will not interfere or contact the child outside of the therapeutic setting.
Yeah. So what's
And if you do
interesting is,
that, there has to be consequences.
yeah, so the target parent, their relationship is okay. So their relationship was already pretty good when the custody was flipped, but there's still that loyalty, that kind of cult mindset of trying to take care of the emotional health of the alienating parent who is acting like they're going to die because
Yeah,
the child is not with them anymore.
yeah. And that's in some situations, there is also underlying issue of enmeshment,
Oh, absolutely.
and which is a very unhealthy dynamic where there could be instances of parentification or adultification, where the child continues to be concerned about how the other parent is doing.
Mm-hmm.
Mom or dad eating, are they taking medicines or medication on timely basis? They must be very lonely.
Mm-hmm.
So it's that failure of the child to individuate from the parent and develop his or her identity that comes into play. And these are tough cases, and that's why it's always advisable in most cases to have the family systems based approach and not just work with one parent and the child in a vacuum and
Mm-hmm.
leave the parent out. I mean, eventually you have to work with the family dynamics as well. And it's a thing that requires patience. It's a thing that requires time. The fix is not going to happen overnight.
Yeah. And patience is so hard for families in these kinds of situations because they already feel such a sense of deep injustice that this even happened and
Right.
got this bad.
Yeah,
So,
absolutely.
Ashish, with this new book, is there something that you think is like a certain tip or advice that people can find in the new book that would make us want to read that one? I already read the first one and loved it, but what's different in this one? I know it's broader, but what did you see as you were writing this one versus the old one, or the former one?
I think some people might be surprised by the new research and data that's coming down the pipeline about men being victims of abuse.
Mm-hmm.
Uh, there's a whole chapter on misperceptions or misunderstandings or fallacies about family violence. That could be important as well. But there
Mm-hmm.
are also practice pointers throughout the book. When you have a case of intimate partner violence or you have a case of child psychological maltreatment or alienation, what works in courtrooms, what doesn't work, what's persuasive, what's not persuasive, when to get a parenting coach to help you with these cases, uh, there's a lot of discussion about vicarious trauma. And this is
Mm,
for professionals who deal with cases involving family violence, secondary trauma, and they get desensitized to violence and there's an emotional numbness to it.
mhm.
The same applies to a parent litigant who is involved in family courts. It takes its toll. So
Yeah,
while you're trying to help your child and we are trying to repair the relationship, you have to ensure that you are able to disengage and you are able to engage in self-care.
not
Whatever that,
easy.
for Chris, for example, that might be getting good ice cream once in a while.
That place in Seattle, did you try Salt and Straw? Oh my gosh,
I
I got
missed it, but I'm going to
4
try.
scoops. I had 4 scoops at once. Yeah, well, I cannot wait to read this new book. And Ashish, can you tell people how to find you? I mean, we're always going to refer people to you, but if they are wanting to find you themselves or how to find your book, how?
Well, my website is www.joshiattorneys.com. But I have a presence on LinkedIn and Facebook, which I use for work, both social media platform. And there are significant amount of resources on my website that's just available free for people to download. My publications, articles that contain a lot of sites to different cases and research studies. You can get everything from that website.
Great.
So
Well,
hopefully
thank
that
you.
should be helpful.
Yes, yes, so much. And Chris wrote a comment about how he had an extra serving at the Mariners game. But anyway, but but thank you so much, Ashish. It was wonderful getting to meet you in person, and I hope to see you later this year at the next conference.
Thank you, Lisa. Always a pleasure to be here with you.
All right, take care.
Bye.
Bye.